Good morning, Community Action. We're letting everybody get dialed in and connected. If you're just joining us, we're asking that your cameras are turned on for today's session. So please get your cameras on. Oh, lots of folks joining
Have
us
to
here.
figure out how to do that, Andrea.
You got this, Shannon. Use your Harry Potter magic.
Part of it's I've got a new computer, so I'm not sure how to do it.
Oh, okay. Gotcha. No, I totally understand how that goes.
So,
Good morning.
Andrew, you didn't tell me that Tom Solberg, my old boss, was going to be on this call. I think I really should disconnect at this point.
Hi, Jim. How you doing?
I'm good. It's so good to see you, Tom.
Nice seeing you too. What's that on your face?
Well, you know, I grew it out a little bit here, but it's definitely hard to pick up without a good black and white camera.
How you been? Doing hockey? You Indy gonna make it to the Final Four?
Well, I hope so. I got tickets to it if they do.
Oh,
Do you really? That's awesome.
My wife is quite adept at selling tickets on the secondhand market if we don't need them. So,
well, you're under pressure because I've been talking you up, man.
He has, Jim.
we talked about you having the integrity to be more honest in life, haven't we, Tom?
Well, good morning, everybody. Thank you so very much for being here. Today's session is being recorded. You maybe got notification on your end that was like you needed to accept. So we're asking Community Action Network, we're asking that all of you please turn your cameras on. Montana, I see your message there. Thank you for that. Shannon, looks like you're up and running with your new computer, so this feels good. Super excited to be here with all of you this morning. We are going to kick things off with our promise of community action. This is my favorite part of large virtual meetings, is when we have some just organized chaos. So join me in reciting our promise of community action. You can unmute, keep yourself muted, whatever works best for you. But join me. Community action changes people's lives, embodies the spirit of hope, improves communities, and makes America a better place to live. We care about the entire community, and we are dedicated to helping people help themselves and each other. Oh, it's my favorite, you guys. Thank you so much for engaging with the promise of community action. We are going to dive into our child support training. But before we get started, just a couple things I want to say. Kind of how did we even end up here? Safari and Holly and I, along with the SSBF team, have been working on some legislative initiatives, some legislative testimony. And one of the things that we talked a lot about was child support. And I won't get into all of the details, but what that created was an opportunity for us to start working with Jim. Huge shout out to Jessica Thomason from DHHS. She was able to connect Cap and D with Jim. Holly and Safari and I met with Jim, and we learned so much. And we know that there's a need for this knowledge to be spread in our network to ensure that we're all informed, that we all have the appropriate tools that we need when it comes to these child support cases. We're super lucky to have Jim Fleming in North Dakota as our child support director. Jim has a very strong reputation for working to find ways to help both parents and children. Jim is a wealth of knowledge based on decades of experience. He has served in various capacities over the years on various national boards and committees, including being the immediate past president of the National Child Support Enforcement Association. And I didn't learn this from Jim. I learned this from Jessica. Dakota, that in November 2023, Jim was actually asked to provide congressional testimony advocating for stronger and fair policies on the federal level. So this is an opportunity for us to learn directly from the source, and a really, really good source. So thank you, Jim, for taking time to be with us today. You know, we all, I think, kind of have some preconceived notions. We have some ideas about child support. What I'm asking you to do right now is to please just put a pin in those, put those aside, and let's get through Jim's session, because we have to understand that child support is a process that has a lot of layers of nuance. Last thing I'm going to say, SSVF folks on the call, I want you to please make sure you're paying extra attention, because Jim's going to share with us some tools today, and we're going to start using those tools. We're going to be deploying those in the practice of our SSVF program. So Jim, thank you for being here with us today. I am very fortunate. I feel very fortunate that you've taken time out of your busy schedule to share it with the Community Action Network. So without further ado, Jim, we'll turn it over to you, and thank you again.
Well, thank you, Andrea. I had a list of things in my head of what I wanted to say at the beginning, and you covered so darn many of them. I mean, as the director of a program that has 165 souls working in it, some of those 165 have the nerve of doing things in certain cases that are outside what agency goals and aspirations are. So I would ask you as well to be open to the idea that if what I'm telling you as the program director does not align with your experience, let's talk about that and work with that, because I need to know that. So if some folks are not maybe understanding our policy or not really abiding by it, that we can work with that. I am the program director, which means that with Jessica's support, I'm the one who sets what our program policy and goals are. And so what I'm going to present them to you. And if they don't align with the child support you've experienced, I really would like to know that. Sometimes we have folks that in the effort to do good are really advocating strongly for the custodial parents on behalf of the kids who need that support. And they maybe are not as sensitive to the predicament of the parent who owes the child support. And we really do try to take a balanced approach. As Andrea said, I've had the good fortune of serving in several national offices recently, and being a national spokesman for the program. And very much child support is about looking at the whole family situation. It hasn't always been that way, but that's certainly where the modern program is working at whole families. Today got kicked off by some scenarios that reflected bad outcomes, and they cried out for learning more about what was going on in the case. And so today we're going to talk about how child support is determined and what our program goals are. Just to let you know a little bit about me, I grew up in Cavalier, North Dakota. I've lived in North Dakota my whole life, except for the times after college that I went to DC for a year to work for Senator Quentin Burdick, if any of you are old enough to remember him, and 3 years at law school at Notre Dame. I kind of said, I came home the slow way. I came home from DC to North Dakota with a 3-year stop in Notre Dame, just because they were willing to put up with me at law school, and it sounded like kind of a cool place to be. I always wanted to be an attorney. When I was a kid in Cavalier, I got my learner's permit at 14. My dad was a trial attorney. He represented a lot of low-income parents. He did a lot of pro bono work. He had the indigent defense contract. When he had a child who could drive, he thought that was a great excuse to have a chauffeur that worked for free. And so during my summers, I was growing up taking him to all the little courthouses up in the northern part of the state, down to Grand Forks. And I sat in the back of the courtroom watching him represent criminal defendants, representing people in civil cases that needed an advocate. And that really formed my goals in life and the work that I wanted to do. And so I went to law school, had the chance to come back, and I got a job with the North Dakota Supreme Court for a year. After that, I started in the Attorney General's office in 1994. They gave me the portfolio called Human Services, which included child support. And so I started to work in child support in 1994. In 2002, they had a deputy position open, and I applied for that and said, you know, if you hire me, you ought to bring the lawyer job with me. And so that's where I started in-house to Human Services in 2002. And I've been the state director for about 13 and a half years. So I've been the deputy or director for 21 years now. And it's given me a lot of chance to get familiar with child support policy and goals. With regard to the veteran population, just to be personal for a minute, 7 years ago, my dad, my role model, my dad died as a result of Agent Orange exposure and related liver cancer. He fought that for 20 years, and eventually it got the better of him. And so when it comes to veterans who served our country and helping them out, it's personal to me. We want to serve that population. And if there's things that we can do to improve communication with that population, that's the least we can do for them standing there and getting shot at as military service people. I really value that. Dad drug us around and we put flags on the graves of Memorial Day. That was our thing right before Memorial Day. And we did that for a decade. Then we stood there and stood at attention as they gave a beer to the guy that used to do that, who was buried. And his request was, guys, give me that annual beer every year. Just sit there and give me a thought for a minute. So that's a little bit about me and why, when it comes to those who need help from the civil justice system, I'm sensitive to that, but especially if they have done military service. That's the least that we can do. So that's just a little bit about me and what you're hearing from. And I do hope this information is helpful. To give you the highlights, a good presenter will say, you tell them what you're going to tell them, and then tell them, and then remind them what you told them the three times. So what you're going to hear is that child support is based as a percentage of income of the parent that owes the child support. So one of the scenarios is, well, this person owes $2,000 of support for 4 kids. Well, you're going to know at the end of this session how to find the child support guidelines and how to look up that amount on the guidelines and say, in order for that parent to properly have a $2,000 a month obligation for 4 kids, they're going to have monthly net income in the range of $5,350. That gives you an idea of how that obligation got set. That begins the process where you can reverse engineer what happened and say, okay, if that's their kind of income, I'm not going to be too sympathetic to them. But if that's not their income, then let's talk about how it got there in the first place and what we can do about it. So that's one of the big takeaways. The other takeaway is that when you're working with non-custodial parents, they're not always going to be open to talking to child support. And the reality is that we will file a motion to reduce a child support obligation. We are not all about more. We are about equity. We are about having a sustainable, appropriate obligation. So if somebody's got stuck with a $2,000 a month obligation because that's what was proposed in court and they didn't get the documents and they didn't respond, child support offers a service where if the order is 18 months or older, we will pursue a modification that will bring it to a more sustainable and appropriate income-based level. So they may not trust us, but you're hearing from me directly that that's a service we can offer. So if you're able to get a release from the customer and work with us, we can get through what that person's income is more appropriate. There's also a calculator on our website. I didn't put that in my handouts, but you go on to childsupportnd.com. There's a child support calculator where you can sit with the person you're working with, and you can put their income into that calculator and get an idea of what their obligation ought to be under the guidelines. So presentation I got today was going to cover that, but those are the real highlights, is that if it's too high, there's reasons to look into it and there's ways to fix it if it is indeed set too high.
Jim, I just put a link to the calculator in the chat for everybody.
Awesome. So I'm going to share the screen and hopefully this will work. Y'all see the dad and the kid riding a bike?
Sure do. We do.
Awesome. All right. So the title of this presentation is Serving Families to Promote Self-Sufficiency. We are a collection agency, and we are smart enough to realize that if we leave a parent penniless, the future for them paying is not going to be very good because they're going to be broke and homeless and hungry and desperate to avoid child support. What we are looking at is some kind of a sustainable income-based obligation and expectations that allow them, the parent, to not run in fear from child support, but rather to live with that obligation, just like the other financial obligations that they have in life. This slide shows the services that our program offers. We do have a very helpful website and an interactive phone system that's available all the time. We will establish paternity if it's needed. A lot of times that's going to be for non-married parents, it's going to get established through a voluntary acknowledgement process in the hospital. The parents are advised that they have the right to genetic tests and they can waive that right and acknowledge the parentage of the child. It works just like a paternity judgment, only you don't go to court, and it provides the basis for child support obligation. Child support will establish and modify orders for child support and for medical support. This will be based on child support guidelines that'll be linked in the presentation. Those are part of the administrative code. And we will do periodic reviews, as I mentioned. Most of you are aware that we do a lot of enforcement. Our primary enforcement method is income withholding, which is a child support specific version of garnishment. It has priority over all other garnishments. So essentially child support is in line first. We do offset anybody who's getting a tax refund that owes past due support. We are empowered to suspend licenses. I'm going to get into that process because it's frequently misunderstood. And it's one of our leading methods of managing cases. So we want to talk about that. We also have in our array of tools for enforcement, we also have an employment assistance project that we partner with the TANF program and with Job Service North Dakota. And what that is meant to do is to work with parents who owe child support and are not able to pay because they're having some struggles finding work. And if the court finds that it's appropriate for the parent to be referred to this program, or if the parent asks child support for an administrative referral, we can connect those parents with specialized caseworkers from Job Service North Dakota who can help them find work and address any barriers to employment that they may be facing. We also do account management, which involves, if it's to be paid as child support, it must come through my office. You cannot pay the custodial parent directly. You will not get credit for it, and it'll be looked at as a gift. It will not be part of your legal obligation. So it all needs to go through the state disbursement unit. People try to say, well, it takes too long, and so I just want to pay directly. And it's like, the answer to that is, well, we use electronic deposit processes, and the payments are uploaded to the Bank of North Dakota for disbursement every night. So if the payment is not received very quickly, it's more likely that we do not have a current address or a current bank account for the recipient parent. But in terms of the payment processes, it's very electronic and it's very fast. We give customers the option of providing a direct deposit debit or a direct deposit account, or we will issue them a debit card. Not every child support case is the same. We are a federally mandated program. In another slide, I'll talk about how you get a full service case or a limited service case. In all cases, the customers have access to our customer service. We have account management, so the payments have to go through our office, and they're all subject to income withholding. If you have a full service case, we'll also establish paternity and support orders. We'll pursue all the full array of enforcement actions and not just income withholding. You will get access to that employment program with Job Service, and you will get periodic reviews. So I'm going to guess that some of the folks that you'll be working with do not currently have a full service case. In order to get child support help to file a motion to reduce the child support, they're going to need to file an application for services. So we're allowed to do that work. To get a full service case, we get referrals from TANF, Medicaid, and foster care. If another state asks for our help, that's part of our obligation, is to cooperate with that other jurisdiction. And then a parent can apply for our services. It does not have to be the custodial parent. It can be the payor parent. And so it is the application itself, there is no fee for that. We do our work for free, except for an annual fee that Congress makes us charge. It is charged once the collections in a case in the course of the federal fiscal year exceed, I think, $550, and it's a $35 fee. So it's not an enormous fee. It is something the feds require us to charge. And it's only charged if there actually are collections. What happens is it's deducted from the amount that the family receives. To give you an idea of the footprint of child support, we, as a 22, we serve 67,000 children, 86,000 parents spread out over 53,000 cases. We got 32,000 full service, 20,000 limited. And we work with every employer in North Dakota and lots of employers that do business in other states. So we're almost up to 80,000 employers that we work with. We have a very large footprint of people that are impacted by child support. To look at that graphically, that comes out to 1 in 3 kids are involved in child support, 1 in 5 North Dakotans, and 1 in 7 adults. So there's a lot of people in North Dakota interact with our program, and we want to try to provide good customer service. We call them customers. Other states don't refer to them as customers. We try to avoid clients, because we do not form an attorney-client relationship with the parent, even though we do have lots of attorneys, and they will sometimes be speaking with those parents, and our interests would align, but we are a separate third party. As a program, what we are looking at and attempting to improve is that there are 20,000 parents out there getting those limited services that are not getting full services. And we feel that our program offers value, and we would like to see a lot more of those 20,000 families be receiving the full services of the program. It might be improved enforcement, but it may also be more responsive case management when the payor parent loses a job or experiences other health-related challenges, for example. We do, compared to other programs and in general, parents in North Dakota do a really good job supporting their kids. We don't throw the phrase deadbeat around because it's way too judgmental. It's a stereotype, and it's frankly just not accurate much of the time. There is $27 million of support every year that is not received in the month when it's due. There's $130 million that is. We are pushing up close to 80% of the current support that accrues every month is collected in full and on time. 80%. For the remainder of that, we collect a lot of that back in the form of arrears. Sometimes a parent changes jobs. In 1 month, they won't be able to make the full payment. The next month, when they get their new job and they start having wage withholding, we're going to be making up that arrearage and collecting it within a fairly short period of time. So it is not an accurate impression to think that most people don't pay their child support. Most people do. And those that don't quite often have legitimate reasons for it that we can adapt to in child support and roll with over our future case management. There's $250 million of past due support in our full service cases. It sounds like a lot. That amount used to increase by $10 to $12 million every year, and that number is actually lower than it's been 7 years ago. So that just gives you an idea that by having a balanced approach, by working with parents to achieve sustainable payable obligations, we're actually working that $250 million down all the time. But it still is a very large number, obviously, and we want to get that to families. Speaking of getting it to families, I'll talk about the fifth of these bullet items. There's all kinds of myths about child support. But the fifth one, the state keeps most of the money to reimburse itself. Child support started out that way in the late 80s, but the reality today is that less than 5% of child support is kept by the state to reimburse itself. It's more like about 3% when you take out the interstate cases where we send it to another place. So we're talking about 97% of what we do, of what we collect, is turned around to parents within 2 days for them to use to meet their needs. Looking at some of the other myths, the higher the obligation, the better. That is absolutely not true. We want to collect all of the current support that is due, and we want to collect the arrears. If a parent's best case scenario allows them to afford $250, If child support a month, if child support gets a court to sign off on $1,000 a month obligation, the best they can pay is $250. We're going to collect at 25%. That is a very bad collection rate. If it's right sized, which is our term of art for having an obligation that's appropriate based on income of the parent, if the obligation is right sized at the $250, then we've collected 100% of what is due. The custodial parent knows what they're supposed to be getting, and they actually can rely on it because it's a sustainable amount. So the notion that the higher the better is just not true. We are looking for an income-based obligation. What the guidelines tell us is the right amount. That is our goal, not any higher. The amount owed goes up but never comes down. I've talked to you about that already. Is if a parent applies for our services to review an obligation, we will file a motion to change the obligation, whether it's up or down. We don't go to the trouble of filing a motion with the court unless there's a 15% change, but that 15% can be up or down in either direction, and child support will file the motion. A parent or a parent through an attorney can file their own motion at any time to modify the amount. So it's not, if child support says, yeah, it's not 15%, we're not going to do it, the parent still can. The system is biased against men. There's no doubt that at the origins of the program, and even to some extent today, that there are more men payors than women payors. That breakdown continues to get closer all the time as we see more joint parenting situations, as we see evolution of the parenting roles, where dads are expected to do as much child nurturing and caring as moms are. And likewise, moms are expected to be earners for the household, just like dads are. Another myth is that we want to collect as much as possible up front. And we'll talk about that in terms of some of the enforcement scenarios that we're looking up against. But again, if child support squeezes a parent, and I use that word deliberately, if a child support squeezes a parent for every penny they have, they will not be able to provide for themselves. They will not be able to make payments next month. They will be evicted from their home. What we are looking to do when we are trying to recoup arrears is we are trying to collect a significant amount, an appropriate amount that is sustainable for the parent to get caught up again. For income withholding and our other collection methods, we are usually looking for an installment towards the past due support in the neighborhood of 20% of what the current support is. And so again, if the current support is based on income, then the 20% is also based on income. So it is still designed to be a sustainable, payable amount for the parent that owes the child support. Something that we get frequently thrown at us is that we fund our budget based on what is collected. Since North Dakota collects 80% of child support, that must mean that Jim Fleming has a Rolls Royce sitting in the garage. This is not how our program is funded. We have deliberately avoided being funded based on the amounts that the state recoups for public assistance. Instead, we have a budget, just like other state agencies have a budget. We incur expenses to perform our work as budgeted by the legislature. And what we incur for expenses, we submit to the federal government, and they give us 66% reimbursement. So it is not based on how much we collect. It is based on how much the state has budgeted for child support activities. And the legislature does that knowing that of the activities they are budgeting, 34% of that will be funded by North Dakota taxpayers and 66% will be funded by the federal government. Lastly, child support throws me in jail for non-payment. I don't have that kind of power. Only a court can do that. And under the Due Process Clause of the Constitution, as well as other statutes in North Dakota, a court cannot throw you in jail for non-payment. On the civil side, it must be for a willful failure, and the parent needs to have the keys to the jail in their own hands, which means that the parent has the ability to purge and get out of jail by doing what the judge wants them to do. There is a theoretical possibility of a criminal charge. Again, that would be proof beyond a reasonable doubt of intentional non-payment or willful non-payment. And that would happen after a criminal trial with a judge and a jury. It is not something that child support has the power to do as an administrative agency. In terms of how our program measures success, and this is guided in part by some federal performance measures that apply to all states. What we're looking to do with child support and the role of the guidelines is to replace the financial support the child would receive if the parents lived together. I used to use Bill Gates as my example, but these days it's probably Elon Musk or Jeff Bezos are better examples. But the child support obligation for parents with that kind of income is going to be much higher than the obligation of a parent who has a blue collar job and punches a clock at the beginning and the end of the day. It's going to be income based and it's going to fluctuate. And the reason for that is that if those payor parents were still in an intact household with the other parent and the child, their standard of living would vary based on the income of the parents collectively. So it is not like TANF or Medicaid, which are income based, and they provide a minimum floor of child support. Instead, the amount of child support that's due from the parent is based on what that parent's income might be or their ability to earn. In North Dakota, we don't take a proportionate approach looking at the income of both parents. In a lot of states, they do that, and there is some wisdom to that because then you've got a proportionate breakdown. North Dakota uses a method where the support from the custodial parent is presumed to be in kind and is not taken into account, and the absent parent's income is what's used exclusively to determine their obligation. What that does is it removes the argument that a parent's child support obligation is being negatively impacted by the life choices of the other parent. Now, what do I mean by that? Well, if you went with an income shares model, which is the label for when you look at the proportionate income of both parents, either parent could be complaining that the other parent is dogging it, that they are making life choices, they're making job choices that don't maximize income to support the child. We all know that job choices are not just based on income, but they're how much they pay, but also quality of life, where you're living, what the work is. Is it work you enjoy? Is it not work you enjoy? These are people who don't live together for a reason. And to have that lifelong or that ongoing meddling in each other's job choices is just not something the legislature thought was a very good idea. And so instead, they've looked at it and said the obligation of a non-custodial parent should be based on what they earn without regard to what the other parent does. That's their deal. The parent will base it only on what the parent's earnings are. And I've mentioned several times, but what we're looking at is for child support, we're looking at the number 196. We have 18 years at 12 months a year for child support obligations. We're playing for the long game. We need to be doing a case management approach that will reflect the fact that we could have upwards of 196 monthly payments that we want to receive. And our goal is to try to have that happen in as many of those 196 months as possible. So some of the scenarios that were presented to the legislature to talk about, I mentioned the first one. Parent owes $2,000 a month for 4 children. Now in North Dakota, the child support guidelines are adopted in the administrative code. And the table is out there in the public for all to see. I'm going to try to link to that and hopefully it'll work.
And Jim,
Andrea,
while you're doing that, just a heads up, we did put the calculator into the chat, and
perfect.
we can get to that site, but when you have to click on calculator, it's that Excel document. We're having problems getting that guy working.
Oh, I think that has to do with the security settings that you have.
Oh, okay. Well, I don't want to, divert the presentation. I just wanted to interject that while you're looking up those guidelines.
I don't remember the fix, but I know that when I've shared this with private attorneys, that our system help desk has explained how the user can change their security settings in a way that allows them to do it.
Perfect. We will look into that, Jim.
Okay.
Thank you.
You bet. Andrea, are you seeing the beginnings of that guideline table on the screen?
No, sir, just the little girl with the cute headphones
shoot.
and she's
All right.
rocking out.
You'll
Yeah.
have to, if you stop share and then you'll share again to the correct screen.
Oh, thank you very much for the technical aid. All right, and we'll hit the share button there. All right, now I bet you're seeing that.
Yep.
So this is on the web, and the link is in the presentation, and Andrea's got the presentation with my blessing to share it with you all after this session. So you've got it in your files. This table, you look on the left side, obligor's monthly net income. Now, net income for child support is gross income from all sources, minus hypothetical federal and state tax calculations, minus Social Security withholdings. There's a few other deductions if the person has mandatory work expenses that are not reimbursed by the employer. So it's fair to say that monthly net income is gross income after taxes. And the numbers you'll see in the columns, 1, 2, 3, and 4 children, 5 or 6 or more. In the scenario where the person was owing $2,000 for 4 children. Now, close your eyes because I'm going to scroll quickly. But if we look at this column where it says 4 children, you can scroll down to the table, and you got to go quite a ways to get to the 2,000. Here's as close we get is 2031. And you look on the left-hand side. In order to lead to a $2,031 monthly obligation for 4 kids, that would be based on a net income after taxes of $5,400. If that matches what this parent is earning, then that is an accurate, appropriate obligation. If that doesn't match, then it begs the question, okay, how come? How come? The person might have made $5,400 a month net at one time, and the obligation is still based on that. And if they're no longer earning that, then maybe a change is warranted. If a person is not cooperative in establishing the obligation in the first place, the attorney for the other side or child support is going to be looking around for income history. And they're going to use that history unless the parent participates and says, no, that's not the right amount. Here's what my income is. So there's different ways you can get to amounts where it's no longer matching. But if someone comes to you and says, I owe too much child support that I can't afford, one of the first things to do is to go to these guidelines and say, well, for that amount to be correct, this is the kind of income it's based on. And then what you can also do, and I'm going to stop sharing now and go back to the presentation. What you can also do is go to the Odyssey system, which is the court's public record system. And you can, if it's a North Dakota support order, you can look at you can read the order for yourself, and the orders are supposed to explain how you got to the income on which the obligation is based. So if you're working with a homeless veteran now, and the obligation just seems way too high and very much out of whack, if it's a North Dakota support order, you'll be able to go into Odyssey and look at the order, and you'll see, oh, well, this obligation was established when the person was an executive for a company and was making a really good salary. That begins to fulfill the picture, because now you know how it got to that big number in the first place. Now you can look and say, all right, well, that's no longer accurate. That's no longer the present day. That's not where this person is today. When you're in Odyssey, before you close that out, take a look at that support order and see how old it is. If it's if it's more than 18 months old, now you've got the opportunity to say, okay, this is something that child support would be willing to review. So let's talk to the parent about what their current income is. Maybe pull up that calculator once we get the security settings tweaked. What would be the appropriate amount? How can we get, if that's going to be something that is lower, then let's talk about following up with my child support worker if I have one. And if I don't have a child support case, let's look at getting an application for services on the child support website, so that they can apply it and apply for services and get what they need. There's scenarios where a parent loses his or her job or gets hurt. One of the first questions I would suggest you ask is, have you told child support? Child support will respond to that. we can't magically make the court order stop accruing. That still takes a motion to the court, and the courts don't want to get those motions if it's going to be brief. But if there's a reason why there's a brief interruption in payments, child support can take that into account and back off of some of the other enforcement things that are going on. If somebody's getting hurt at work and they've got a workers' comp claim pending, that's a lousy time to begin a license suspension action, because there's a reason why they haven't been paying, and it's a good reason. Another scenario is I'm still paying for 2 children, even though one of them has graduated from high school. You want to take a look at the court order. If child support gets a child support order for multiple kids, for siblings, child support will write it in a way that says when there's 2 kids that are living in the home, this is the number. When the oldest child graduates from high school or turns 19, whichever happens first, then this amount will be reduced to a 1-child obligation. Child support program will do that in our documents, but we still can't get private attorneys or parents to always make that distinction in the orders that they write for the judge. So if that order does not anticipate the graduation of the oldest child, the amount that's due is going to keep accruing until the court modifies it. Another scenario that was raised in the examples to the Legislative Interim Committee is that 50% of disposable earnings have been withheld. Well, if you look at that table in the guidelines, if you remember that, even for the $2,000 a month for 4 kids is a lot. 2,000, it was compared to net income of almost $5,400. That's not 50%. For 4 kids, it's getting up there to about 35 or 40%, but it's still not 50. 50%.
Hey, Jim.
Go ahead.
I'm sorry, Jim. I don't mean to interrupt you, but this is one that comes up a lot. And in fact, we just had this situation present itself in Minot maybe a week or so ago. And this is where I really want to make sure that everybody's paying attention, especially the SSVF folks, because all these tools that Jim's talking about, we're deploying these in the program. So you're not going to be able to make a referral to Tim Lamb and say this veteran is paying more than 50% of their income. You're going to have to do your homework before we make that referral to Tim Lamb. So SSVF practitioners on the call, I hope you're paying extra special attention because we will be deploying these tools as soon as this training is done. I don't know if you're all here, like Jenny and Alicia, you guys have your cameras off. So I just want to make sure that you're hearing this too. Thanks, Jim. Oh, Jim, I'm sorry. One more thing I wanted to say. If somebody comes in and says, we're paying more than 50% of our income for child support, to me, that's just a huge red flag that something's wrong. Is that the appropriate thought process? Like, wait a second, this is impossible, right?
It is. And it would be really hard to say it's more than 50%, because then you're not talking about just income withholding. When you look at 50%, that's the threat. That is the maximum amount that can be withheld from income under an income withholding order. So let's say, for example, we have that parent who owes $2,000 for 4 kids. That income withholding order is going to be issued for $2,000 or 50% of disposable earnings, whichever's less, because federal law caps withholding at 50% of disposable earnings. So yes, Andrea, your assessment is correct. If they are hitting that 50% threshold, that suggests that there's a difference between the income that is used for the obligation and the income that the parent is earning from that employer. Now, sometimes that happens because you've got a parent who has 2 or 3 part-time jobs, and not any of those jobs by itself produces wages in an amount sufficient to satisfy the child support. So you might get 50% cap on the first employer, maybe even the second one, but not the third one. But definitely when you're running up against that 50% cap, it begs for more questions. And the odds are very good in that scenario that the obligation exceeds what they're earning today, which may mean because the order is too high, or it may mean that the parent you're working with is voluntarily underemployed. I've got some slides at the end of this presentation to talk about how we differentiate between the good underemployed and the bad underemployed. But one of the very important questions to say is, all right, if 50% is being withheld, when was the last time the obligation was reviewed? Because it may have been based on earnings that the parent is no longer able to achieve, and that cries out for a review. And lastly, my driver's license has been suspended. So we are not able to take a person's license and turn it into DOT and get cash for child support. Well, they're not redeemable for cash. What we're talking about is negotiating with the parent, motivating them to cooperate with child support, giving them an incentive to cooperate. We don't want to suspend licenses. What we want to do is we want the avoidance of suspension to motivate the parent to make the payments that they're supposed to be making. So in order to make that work, what you have to do is, and the law says that we have to send a notice to the parent in advance that says, we are hereby giving you notice of our intent to suspend your license if you don't pay your child support or negotiate a payment plan with child support. It's going to happen in 30 days. That's what the notice says. But especially for your homeless parents, the law says that you can send those notices to the last known address, and it's good enough. And that's a federal mandate, and it's meant to not reward people who are avoiding child support. If you forget to tell, if you deliberately don't tell child support where you're living, you're not going to get away with that in terms of avoiding notices and avoiding enforcement actions. But for homeless parents, it's a two-edged sword, because they don't have an address to which you can get these notices. We want them to get the notice. The whole point is to get a conversation going with these parents to avoid the suspension in the first place. But if the driver's license was suspended, the person's probably not going to say, well, I didn't get the notice. Now, sometimes they do, and they just don't want to fess up to that. Sometimes they don't. Question to ask is, have you kept child support up to date on where you are? Because if they don't know where to mail your notice, you're probably not going to get it. And that notice then will not warn you that this is going to happen. And the first you hear about it is when you get stopped for speeding or whatever it might be, and law enforcement tells you that your license is suspended. We don't want to get them suspended. We want to use that as the opportunity to get into a long-term payment plan that provides for payment of current support and a sustainable amount, plus it's usually a 20% add-on to be paid towards the unsatisfied child support. Andrea, how are we doing for questions?
Yep. We have a question in the chat. If a person is struggling with child support obligation due to finding fulfilling employment, and they are communicating with child support, how often are they able to get a review?
Our policy is to do a review every 18 months from the last time that the obligation was changed or the last time it was reviewed by child support. So you look at the court order that's governing the obligation. If it's more than 18 months old, it's very likely ripe for review. The time that wouldn't be true is if child support looked at it last month and it didn't hit that 15% threshold. Well, that is the review, and it won't occur again for another 17 months. But 18 months, I think, is the short answer to that question.
Okay. Another question. I also thought that child support was also based on custody arrangements. So someone who has 50-50 custody, then child support would be lower than 100%.
Well, and we are seeing more 50-50s. I wouldn't describe it the way that the questioner did, but it comes out about that way in the end. And it's true. Since the North Dakota looks at the income of both of only the parent without custody, when they share 50-50, we actually obtain income from both parents, income information from both parents. We apply the guidelines amount to both parents separately. And that's what each of them would owe. But we also recognize that having both parents pay in full is kind of dumb. So what the guidelines provide is that the lower obligation will be offset against the higher one. And so one of the parents will owe zero net difference, and the other parent will only owe the net difference. So that's how we can apply our obligor-based approach and recognize that in a 50-50 that technically they are both obligors. just half the time. That's how the calculation would go. So in the end of that, yes, the net amount that's paid is much lower because it reflects the difference between the two parents' obligations.
We've got another question here. Kate, I'm going to ask you to take yourself off mute and please ask Jim your question.
I was just wondering, so if someone is homeless when they are first being asked to pay child support, would the notice of needing to make payments also go to their last known address, like the notice of a suspended license, or what is the other method of contact to inform them that they need to make payments?
So when an obligation is first established, it needs to be personally served on the person. So we would give the complaint to the sheriff and ask them to serve it personally on the parent. If that didn't work, we could try certified mail, but in your hypothetical, they're homeless, so really there is no mail address. We can do a service by publication. We don't do that a lot, even though it's legally permitted, because it's not terribly effective. But if we personally serve a homeless person, that begins a process towards the obligation. And it will be, there's not a good solution to what you're describing. We would be trying to work with that parent. We would be struggling to try to get them the notice or to find ways that we could communicate. What we have floated with Andrea and her team is whether Community Action would be willing to receive that mail on behalf of the homeless veterans and then get it to them and talk to them about what's next. And so that would really help us bridge that communication gap. But we may not have a very good address. And in that case, we're just looking to encourage the parent to find ways of talking to child support, walking into the child support office, getting us on the phone to make an appointment, somehow cooperating with us so they can provide their income information or lack of information. And so the obligation will be something that's sustainable. Sustainable for a homeless person is the bottom for an obligation, short of a disability, is going to be minimum wage full time, which for one child would lead to an obligation of $190 a month. It's still not going to be terribly sustainable for a homeless person, but the law is set up in a way to say that unless there's some disability, we do expect parents to have gainful employment in one way or the other of 40 hours a week at the federal minimum wage. So I know in true lawyer fashion, I gave you a 1,000,000-word answer to a simple question. Getting us the address is going to be hard. They're going to be legally required to give the court the address, but their address is I'm homeless, and communication will forever be a challenge in that case.
So just to follow up, so if there was an issue getting communication, when does that trying to inform them that they need to make payments turn into they are technically missing payments if they're not able to be contacted or reached?
Well, once they're personally served, if they do not participate in the court action, that it will proceed to a default judgment and they will owe that money. Without a good address, they're not going to be getting those notices. We will use, child support will try to find that person and be continually trolling for a good address, even if it's just more of a hotel or a temporary place to live. But I think it answers your question to say they will ultimately get that obligation. And to the extent child support can find income or assets, it will be enforced.
Okay, we got questions in the chat. So Tia, could you ask your question?
Yes. So I personally had a client who had to pay, his obligation was way more than like his paycheck. And so it was a lot, and I don't think he informed child support in time. And so my question was, if there's ever an income change that's larger than 15%, can he report that before the 18 months is up? Like, can a motion be filed before that 18th month review is due? Or how?
Yes.
Okay. So
Yes.
they don't.
That the he in that situation would need to file the motion himself or have an attorney or advocates probably couldn't help, but they could help fill out the pro se forms. They would need to do it themselves because child support would look at it and say, yeah, it's not 18 years old yet, and we're just not staffed up to do it more frequently than that. The federal minimum's 36 months, so we're already chopping that in half. But
So,
they definitely could file that motion. But yeah, the other thing, even if it wouldn't lead to a change in the obligation, um, if that job change was the result of maybe an employer closing down operations and not just that the parent quit because they didn't want to work that hard. If they quit that job in good faith, that can impact how child support enforces the case while the parent looks for a better paying job or tries to get back to something that's close to what their previous earnings were.
okay. So how often should income changes be reported to child support if it's not within that 18th month period?
So state law and the child support order both impose an ongoing responsibility of the parent to tell child support when they change address or change jobs. So that parent should be telling child support every time they change jobs.
Thanks, Jim. I know we're getting close on time, so are you able to go past 10:30 or no?
I am if you are.
Okay, because I am.
Okay.
There's one more question so far. Nika, could you ask your question?
Yeah, is a custodial parent able to file for child support if they've not legally separated from their former partner yet, so there's no court orders?
Yes.
Okay.
Yes. Most of child support's clientele or customers are never married, and thus there is no divorce that sets out custody. So if the parent applies for services and they say, I have the child in my care the majority of the time, then we will take that as true and begin the establishment process and leave it to the other parent to say, I got the child the majority of the time. That would be how that would be resolved.
So in this instance where if they are married and it's kind of just a informal unspoken agreement, that they might be pursuing divorce proceedings, they might not be, it's kind of a, I don't want to say like hostile situation between the parents,
Right.
but legally still married.
Yes. We would still take the case. We would establish child support. Like I said, in asking the court to establish child support, there would be an allegation that the child is with this mom, if you will, in that case, is with the mom more, the majority of the time. And like other things that are alleged in a complaint, if the other side doesn't agree, it's their responsibility to disagree or dispute that. And then the court gets to figure out who's telling the truth. Most of the time, it's really not disputed. I mean, the parents have gotten separated. Maybe mom moved out of the house and took the kids with. There's no real question of fact about whether the child is with the dad half the time or not. So if mom comes in and says, I moved out from my husband, took the kids with me, and I need some child support, that would be all that would needed for us to begin the establishment process.
All right.
Okay.
Are you ready?
I am. Let's just get through about the last 3 slides or so,
Okay.
if we could,
Sure.
and then we can
Let's
throw
do
it
it.
wide open, and I'll stick around until the questions run out. How's that?
Thank you.
So we've talked today about being able to look at Odyssey for the court order, looking at the guidelines to see how the math is. You can help people by looking at those 2 sources and find out where the disconnect is. The order might explain how the income was determined. You can look at the guidelines and say, well, in order for this amount to remain accurate, they would have to have income in this amount. I don't think that's legit anymore. So those are ways of doing it. Your agency can help us maintain that line of communication. If the parent has a legitimate job change And I can think in particular, Melrose and Bismarck many years ago laid off a whole bunch of parents in their 50s. And they'd been with Melrose for 20 some years. And their prospects of getting equal income in their 50s was very, very small. I mean, that was really important for us to have a good line of communication. We worked with the employer and local legislators to have that line of communication so we could work with that. What we're looking for is a sustainable monthly payment plan. Arrears, once they become past due, they accrue interest. And it's an equity thing. If the custodial parent doesn't get child support on time, the credit card company is not going to shut off interest and wait for them to find child support to pay. They're going to be accruing interest. They might be facing eviction. They're going to have to dip into their own resources, an extra amount to make up the deficit. So interest, it does accrue. There are ways for a parent to avoid accruing interest as long as they are making those monthly payments. And we offer that as an incentive for parents to enter into payment plans with child support and stay current with those plans. Because while they're current with the plan, we will shut off interest accrual. Under the law, we have that authority. And so the parent is making payments on current support and they're paying on principal only. Additional interest is not accruing. And that's a big thing, especially if you've gotten 5 figures of arrears. We do look to see if the failure to pay is willful, because if it is, you can be looking at some potential court contempt. Something else that is one of the participants asked a question about the parent who had a job change. It is really important to bring that forward as fast as possible, because you can't go back retroactively and make arrears go away because the parent's income changed. The order is the order. The monthly accrual is untouchable until the court modifies it. You can't go retro. So it's really important when that income is changed to act promptly so the amount of the obligation can be changed by the court and that higher amount is no longer accruing as an arrears. Because once it accrues, it's owed and it's not going away. And we talked about the challenge of having an address. The lack of a good address does not block child support from taking these actions. And so we really do work hard to maintain a good address because, like I said, our goal is really not to suspend licenses. We just want to use the avoidance of that as a way of getting those regular payments. So quite likely the parents that you're working with, especially homeless parents, are going to be asked about why they are not working. Under the child support guidelines, it's not just the actual income that they make, but income can be deemed to be, it can be applied to them if they are underemployed. And what it was meant to do is to prevent parents from voluntarily tanking their own jobs and reducing their own income just to avoid paying child support. And there were parents who were doing that. And so what you see in the guidelines are provisions that talk about how you identify underemployed parents. And for those who are underemployed, you deem a certain amount of income or you impute to them a level of income that's reflective of a different criteria. If the person you're working with is earning less than minimum wage or 60% of statewide average earnings, they're going to be presumed to be underemployed. If they're underemployed, you're going to see income imputed at one of 3 things: 40 hours a week minimum wage, 60% of statewide average earnings for someone with comparable qualifications and job history, or 90% of that individual's greatest 12-month average over the current year and the previous 2 years. I know that's lots of words, but again, minimum wage full-time, 60% of what someone in that occupation ought to be making, or 90% of what that person personally was making when they peaked over 12-month average over the last 3 years. So if they're underemployed today, income is going to get imputed to those parents in that amount. If they don't cooperate, the income can be imputed at 100% of what the previous order was. So cooperation is expected and it's really important. There are ways to avoid imputation. You can avoid that if they have a disability. You can avoid it if they're under 18 going to high school. If their actual earnings are at least full-time minimum wage and it's similar to parents with similar work history, you can avoid imputation that way. You can avoid imputation if they're getting SSI, Social Security disability, workers' comp, wage replacement, if they're incarcerated, or if they've recently been released and they were from incarceration where they were sentenced for 180 days or more. Those are ways that you can avoid imputation. But what's going to be critical is that the parent be talking to child support and say, these are the reasons why I can't make what I used to make. I'm going to guess that a good number of the folks who are homeless are very possibly have addiction issues or challenges, or they have mental health challenges. It's going to be really important, and something that you can help with is to communicate those challenges to the child support program. Addiction is generally going to be looked on as something that is within the control of the parent. They're going to have a hard time avoiding imputed income for an addiction. In that context, what you're more likely going to be looking at is how old is the order? Because maybe even in the best case, if what they were making before that they succumbed to the addiction, it was still too high. But you may also be looking at getting some patience on the part of the child support program to pull back a little bit on enforcement while the parent is getting the help that they need. We would be willing to help connect that person to a job service worker who specializes in child support parents so they can do some of that help to address the barriers. Imputation can also be limited to just the minimum wage and not the higher numbers if there's a lack of job opportunities for that person within 100 miles. North Dakota, they still have a very strong sense of community. They don't want to make people move out of their community and move to the big cities of North Dakota just to have that job. Quite often it's going to be moving further from the child. They don't want to do that. So there are ways to avoid the imputation of income, but it's going to be really important that there be an active exchange of information back and forth with child support. And sometimes the parent is going to be viewed as having made voluntary decisions that reduce their income. And the guidelines, honestly, are set up in a way that will not be terribly successful when it comes to reducing child support. Because the kids are still going to need that support. They shouldn't pay less just because the parent has made a voluntary choice to earn less income. So Andrea, that closes the prepared remarks I got. I would love to take any questions that anybody might have about things that I've covered today. I'm sure that I didn't anticipate all the questions.
Well, no, and we've got several coming in, which is great. And folks, I know we're over, so if you needed to boogie, please definitely boogie. And we're just gonna, if you can stay, because Jim's offered to stay and answer some of these questions. Let's see, Nika, we did Nika's question. Max, why don't you go ahead and take yourself off mute and ask your questions about the VA disability?
Hey, Jim. So when we're looking, when the state looks at income, is VA disability income calculated as part of that equation, or is it just, I've got a job, you're only looking at what my job is?
We would look at disability income as income.
Okay.
Because it's disability income, you're likely not to get stuck with imputation. And so, the obligation likely to be pretty low. I know that for certain military benefits, by law, they are exempt from being attached, which means that child support can't send an income withholding to VA to withhold them. It doesn't mean that there's a perception out there I've seen in some chat rooms that means it can't be considered income. That is not true. You just can't attach it. And so what you have is, if that parent doesn't pay, the parent could get brought into court for willfully not paying. And the court is going to say, well, they can't garnish your wages, but you are properly held responsible for that amount of child support.
And then since I got you online, so I know that with our Andrea's vision is, the SSVF case managers, we're going to get more jumping in the deep end of the pool with it. In terms of communication between us and the child support staff, is that going to be kind of like a one-way direct communication with that specific caseworker at that point?
Yes. And what we're going to do is the Department of Human Services has a standard release of information that applies to all of the programs. So you might be familiar with it in other contexts. We're just looking for that parent who signed a release, and you provide the release to child support saying, I'm there, Max, you're allowed to talk to child support worker on this parent's behalf. And then we can talk to you as if we would talk to them, and we can see what we can do about the case.
Awesome. Thank you.
I would add to that, Max, that like these tools that we're learning from Jim today, like child support guidelines, the calculator, requesting a review, all of those things are gonna need to be done before we're making referrals over to Tim Lamb. Out of 13 legal referrals last month, 5 of them were for child support. And not all of them really need a legal intervention. Some of them could have been answered by deploying some of these, which we didn't know about. We don't know what we don't know. So we're learning.
The other thing, Andrea, I would say is I know that your testimony included a case from another state.
Yes.
North Dakota courts are not automatically able to amend an order from another state. If someone still lives where that other state is, that's the state that retains jurisdiction to modify. So the best we can do is convey the request to modify from the parent in North Dakota back to that other state, and that other state's going to apply their own guidelines to see if a modification is warranted.
Jim, we have another question. If someone receives $932 a month in SSI and $466 is taken out every month for child support, is there a way to have this lowered? It makes it hard to survive on $466 a month. This is a child support arrear.
Absolutely. If we pulled up the guidelines, and for time I won't do that, but if we pulled up the guidelines, we have deliberately set the beginning part of the guidelines at the SSI amount. So an SSI recipient should owe 0 child support.
Shannon, I hope that answers your question. And I just put the child support guidelines in the chat again. Jim, another question. What happens when children who were in the custody of one parent then move with the parent who is paying the child support?
What happens is nothing happens automatically or immediately. The order is still the order. The parents can't change what the court has ordered just by having the kid move from one home to the other. So in that scenario, if the parent's intention is for that obligation to stop, they're going to need to go to court to do it. Child support will not undermine a custody decree. So if custody is with mom, for example, and maybe it's a teenage boy's got some disciplinary things, and maybe dad just needs to kind of show him how dads need, or, men need to behave. If they want the child support to legally stop accruing, they're going to need to get into court and have that happen. Child support won't do it as long as custody is with somebody else. As a practical matter, if the mom and dad are getting along, what they might just say is, you know what, mom, when she gets the child support, is going to agree to pay it back to the dad. Whatever is withheld from your wages under the court order, I'll turn it right back to you because, yeah, you're taking care of the kid. That's an informal way of doing it. There's nothing legally wrong about that. But if they truly do want that legal obligation to shut off, they need to get back to court. And child support, if there's no custody, it'll be a different matter. Child support may be able to help that. But if it is a divorce case where custody has been placed with mom, now the kid's living with dad, you're not going to see child support get into that because it opens up a can of worms where mom and dad get into a fight about where the kid is spending more nights. And sometimes it's not about 100% one location or the other, but we're talking shades of gray where maybe it's 55%, 45%, and they're disputing about it or counting nights. You can really get drug into factual disputes in that scenario, and that's what child support is just not well suited to do.
Thank you, Jim. Safari, you have your hand raised. Please go ahead.
Okay.
Jim, I have a quick question. If we're working with a client who has had a judgment and just has no idea, no recollection of what that judgment was, how much they owe, how to do anything, what's the quickest and simplest way for us to help them find their information?
You go on Odyssey. You can search by county and search by name. So if you have enough information from that person, you should be able to get their support order. You might want to ask them, okay, who is the other parent? Because sometimes, people can have children with different partners. But if you get to Odyssey, you find the right order, you print it, you can bring it to them and show them and read them and then talk about what to do about it.
Okay, so in Odyssey, they'd be able to find their order with their monthly payment amount and everything they need.
Yes.
Perfect. Thank you.
Thank you, Jim. What can a client do if their court-appointed child support obligation differs from the calculator? The guidelines and the calculator do not align.
It takes a motion to the court to change the amount. Within 1 year, the motion will have to identify a material change in circumstances, but that bar is pretty low. They could just say, I chose a different job. That's certainly a material change of circumstance. If it's a voluntary change, then the calculator is only as good as the data you put into it. If you are making $10 a month and you put that in the calculator, it's going to look like you need a change. But if they have willingly quit just because they have a girlfriend who's willing to support them, the calculator will suggest that there's a change is warranted, but in reality, the imputation is going to lead to no change in that obligation. That's where imputation kind of comes into it, because if they're making less money, person's got to ask a little bit about, okay, how come? Why is that? If they did not participate in the initial action, child support is not going to aim low, because you're rewarding people then for not giving income information. If they don't participate, they're going to look and say, this is the amount that we feel reflects is appropriate. And it may be on a little bit on the high side. It shouldn't be punitively high. But if a parent doesn't cooperate, child support's not going to reward that by looking for their worst case scenario in income. It's going to be looking at the best case scenario. The parent may now say, all right, I regret that I didn't participate. It's too high. How do I fix it? Within that first year, they have to show material change. That could be a challenge if they can't point to one, because failure to respond is not a material change. But after that year, they could get that, they could file that motion, or they could check with child support after 18 months and they could file it. But it will take a court motion. There's nothing child support can do as a program administratively to change what the court has ordered.
Thank you, Jim. Shelby, you've got your hand up. Go ahead.
Yeah, so I just wanted to ask a question. Some of this discussion has been hard for me because our agency, a lot of us are focused on like housing first, and like we encounter like a lot of clients with a lot of substance use issues, and like there's so many factors that go into like why someone might lose a job or take another job. There's also mental health issues. Like that's something we encounter so much. So it's definitely not a simplified situation. I just kind of was wondering, like, is there any potential future within child support guidelines to be working with like mental health agencies, job service, addiction services, to be flexible with those clients who like are struggling with those issues and like are, like trying to better themselves? Because that's something that we see a lot. And obviously, like, it's not linear, like either sobriety or that kind of progress. So that's just kind of where it's really hard for me, because we work with these clients all the time, and we do our best to support them, and it's not always linear or simplified. So I'm just wondering what kind of, I guess, like if there's any adjustments to that.
Well, and I agree completely that this is not simple. I mean, this is a 60-minute presentation that's meant to give the general rules and things. Imputation is very tricky. But the flip side is that the children need support. And quite often the child support obligations don't even meet half of the child's expenses. There are a lot of low-income parents in North Dakota who will have a difficult time supporting the child, whether they live together or not. Shelby, I would suggest to you that the guidelines already include the flexibility you're talking about. What we would look at is, especially for someone who has an addiction, is to work with them to try to temper the enforcement mechanisms while they are getting the help that they need. But the family that needs the support is not going to have an immediate reduction based on that the payor's predicament, because the need has not changed. And it's a demon, if you will, that the one parent is needing to manage. So we can roll with that. We do have that relationship with job service. Our workers are trained to be responsive and to be compassionate but firm with parents who have those mental health issues or health issues, to try to hold them responsible for the benefit of the kids without being unreasonable about it or being too impatient about it. But it is hard. I mean, this is why it's not all about math. Math gets you to the presumptions and the starting point, but from there, it's more art than science about how you manage a case and try to do right by both parents. It can be hard.
Jim, I did post your slides in the chat so folks can get it there. It's just,
cool.
Yep, now it's in there twice. So it's in there twice. You guys can pull that. Jim, I know that we have gone over time and everybody is, got stuff going on. But one thing I want to reiterate is, Holly, you beat me to it. Jim, when Holly and Safari and I have had conversations with you, you keep saying, stay in touch, communicate with the child support worker. That's a really big piece of all of this.
Right.
I'm going to leave you with just, Darla, we'll sneak your question in here and then we're going to call it after that. We did record today's training, so everybody will get a copy of that. We've put the tools that Jim shared in the chat, and many of those are embedded in the slide deck as well. But we'll finish this off, Jim, with Darla's question here. I know of life situations where the custodial parent is not using the child support money for the child, but for his or her own interests. Is there any way to watch over this better?
Not really. It's something that we frequently hear alleged. But when we look at what the average size of a child support obligation is, the need for an accounting is really not real strong. If you're looking at a minimum wage obligor paying $190 a month for a child that's not yet school age, I mean, how far do you want to go to say, well, that 190 is spent on a trip? It's like, well, how do you separate that 190 that's used on a trip from the regular checkbook of the parent? Certainly at $190 a month is not going to cover daycare or food or half the rent or anything like that. So there are people who want an accounting for it. Quite often when you look at what they're paying, under any stretch of the imagination, it doesn't get halfway from what the child's needs are. And so the accounting would just be mean-spirited and meant to be manipulative of the life choices of the custodial parent. When we deposit the child support into the custodial parent's checking account, that's the checking account they use to pay rent and food, and we don't try to use red dollars instead of green dollars for child support and make sure that you use only the red dollars on this. I mean, it's fungible, but so I guess I won't pretend that it never exists, but you can really get into some judgment of ex-parent or ex-spouses who say, how dare you go on a vacation when I'm paying child support? It's like, are they supposed to live like a monk just because they're owed child support? Or they're not supposed to go out to eat, or heaven forbid, have a beer at a hockey game or something? I mean, that's pretty heavy-handed.
Thank you for that answer, Jim. One more point of clarity. When you use the verbiage Odyssey, are you talking about North Dakota public records, right? The North Dakota court system public records, right?
Yes.
Okay.
Yep.
Perfect. We got that question, so just wanted to provide that clarity. Well, Jim, my goodness, I know you are a very, very busy man, and you have spent 25 extra minutes with us on this Friday morning. That's been a tumultuous weather week for all of us in North Dakota. But really want to thank you, Jim, and your team for all the great work that you folks are doing. I want to thank the Community Action Network for attending today's training. Incredible information that we can absolutely apply to everyday use in our jobs. SSVF folks, remember, we're deploying a new system before we're making referrals to Tim, so that's coming. Everybody have an amazing weekend. Enjoy this beautiful sun today, and thank you so much. We'll see you all later. Have a great weekend. Bye-bye, folks.
Thank you, Jim. Thank you, Jim. Great job.
Thanks, Tom. Great to see you again.
All right, we'll see you.